This is Barry Zalma speaking on Zalma's insurance fraud letter, issue volume 26, issue number 5 from March 1, 2022. This issue deals with several different stories about insurance fraud and case law showing how insurance fraud cannot succeed or should not succeed. It starts with an article called "Liars Never Prosper: How Bankruptcy Fraud Destroyed a Fire Claim." Over the last 54 years I've served in the insurance business, I have faced people with insurance claims who had, shortly before their claim, swore to a bankruptcy court that they only had $500 in jewelry and minimal amounts of personal property to avoid losing their assets to their creditors. One even testified that he lied on his bankruptcy proceeding because he didn't want his creditors to get his airplane. He, by the way, went to jail for bankruptcy fraud and recovered nothing from his insurance claim. It is hard to answer when a person is asked which under oath statement is true, the bankruptcy filing or the claim, both of which are made under oath and both of which can result in a perjury conviction and 5 years in the federal prison. In the case on the Liars Never Prosper, a insured named Rich Marchaka lied to his insurance company about the value and extent of his personal property, and the court found it was an obvious lie since his sworn testimony at bankruptcy just a year or so before was totally small ball and he had no personal property to speak of. He claimed he purchased it all between the time of his bankruptcy and the time of the loss, but that became impossible based on his earnings. It's a long and interesting story to read and is available at Zalma.com by clicking on the link to Zalma's insurance fraud letter. Then there's an article about why false swearing about additional living expense defeated a claim. Mr. Ruiz made a claim for additional living expenses after a fire and collected over $47,000 from his insurer, who only after paying him learned that in fact the additional living expenses lease was signed with his wife, who only used her maiden name in the lease agreement, and as a result, Mr. Ruiz was found to have misrepresented a material fact to his insurance company, lost his entire claim, including the legitimate fire claim, and then the court sent the case back to the trial court to determine how much Mr. Ruiz has to pay his insurance company to reimburse them for the additional living expense monies paid. In addition, this issue contains a man bites dog story where Geico obtained a stay of arbitration from a pharmacy who had filed 467 individual medical arbitrations through the American Arbitration Association and 48 individual lawsuits against Geico, all to collect for personal injury treatments that Geico claimed to be false and fraudulent, excessive, and not worth the effort, since all of the injuries were soft tissue. No-fault insurance, it seems, was designed to save the public and insurance companies money. However, As this suit establishes, it also seems to have encouraged fraud by causing treatment for soft tissue injuries that are often cured with aspirin and heating pans by prescribing very expensive compounded creams. Since each claim is small in the nature of things, maybe $2,000 or $3,000, it takes a stay to resolve the issues, and the U.S. District Court recognized that the fraud needed to stop to protect the parties and the intent of the statute that established no-fault claims, and therefore stayed all of the arbitrations, all of the lawsuits, and determined that the plaintiff pharmacy could not file any additional arbitrations or lawsuits until the issue in the declaratory relief action brought by Geico were resolved. This is an insurance company being proactive to stop insurance fraud, something that should be done by the state of New York to protect the insurer as well as the insureds who are involved in these fraudulent claims. In addition, good news from the Coalition Against Insurance Fraud concerning multiple fraud convictions. Insurance fraud article about insurance fraud in other countries like the United Kingdom, Germany, Sweden, France, Finland, and Kenya. A listing of health insurance fraud convictions, starting with a case where a Massachusetts hospital agreed to pay $14.6 million to the government for overbilling for overlapping surgeries and various sentences for the crime of health insurance fraud. In addition, there's an article about attempts by the U.S. government and state governments to compel insurance personnel to act ethically, and a listing of other than health insurance fraud convictions. In addition, there's a description of the Excellence in Claims Handling program that I have produced and true crime stories of insurance fraud. This video was adapted from Zalma's Insurance Fraud Letter for March 1, 2022, which is available at my website, zalma.com, by linking on the link to Zalma's Insurance Fraud Letter, where you can get this issue and where you can get the issue from February 15, 2022 in PDF format. Thank you for your attention, and please subscribe to the newsletter